Assalamualaikum warahmatullahi wabarakatuh to Dr. Ridwan. My name is ALYA JAZILAH BINTI AMIR, and together with my group members from Mrs. Zara, NUWAIR and partners, which are NUWAIR NAJWA binti JAMADI and Muhammad SYAUQI bin JAMMALUDIN, we will be presenting our work on the Limited Liability Partnership Agreement. As for introduction, Qadri has operated Jauhar Kindergarten as a sole proprietorship in Shah Alam for 8 years, during which the business became well established and acquired substantial assets, including classroom facilities, playground equipment, and 2 MPVs for student transport. 2 years ago, he opened a Seremban branch managed entirely by Riaz, a senior manager who invested no capital but has shown exceptional loyalty and integrity. Under Riaz management, the Seremban branch now outperforms the Shah Alam branch, prompting Qadri to propose forming a limited liability partnership, which is LLP, with him. The objective that we have under our limited liability partnership agreement include the following 5 clauses, which is the first one, capital contribution and allocation of profits. Second one, management structure and voting rights, which is under control clause. The third one, non-competition and confidentiality obligation. And the fourth one, allocation of liabilities and indemnification. And the last one is continuity of employment arrangements.
Assalamualaikum warahmatullahi wabarakatuh. My name is NUWAIR binti JAMADI, and I will explain on the background of this agreement. This limited liability partnership is made as of 15 January 2026. It is between Qadri bin Amshar, referred to as the first partner, Riaz bin Izul as the second partner, Anak Kanda Cemerlang Sendirian Berhad, the third partner, and also Jauhar Kindergarten PLT, which is the fourth partner.
As for the capital contribution, the first partners include existing asset of Jauhar Kindergarten, including classroom furniture, playground equipment, goodwill, and 2 MPVs for the student. And for the second partner, industrial expertise, labor, and management skills included. And the last one, for the third partner, sum of cash of 200,000 ringgit Malaysia, strategic networking services, including securing corporate sponsor, included under the third partner. Next, as for the profit distribution, the first partner will gain 60% of the profit, and for the second partner, he will be getting 15% of the profit, and the third partner will be getting 25% of the profit. And the drafting notes under this clause is list first partner physical asset as capital, making sure ownership share is recognized alongside all-in's cash, recognize second partner non-monetary contributions, and also third partner cash investment. As for the management authority, the first partner will be the day-to-day management of the Shah Alam branch, and the second partner will be the day-to-day management of the Seremban branch, and strategic decision involving the third partner shall be decided by a vote of the partners, and the voting right will go by first partner is 60%, and second partner 10%, and third partner 30%. Furthermore, under the clause of reserved matters, any decision to alter the nature of the business, which is sell the substantial assets of the LLP or admit new partners, requires a majority vote of at least 75%, effectively granting the first partner veto power. And the drafting notes under this clause is the first partner asked to retain 60% of the voting power, even though the third partner contributed the most money. This clause separates the voting rights from each partner's investment so that the first partner may retain control and cannot be outvoted by Alin.
I will continue for the non-competition and confidentiality parts. For confidentiality and data protection, the third partner acknowledges that in the course of the partnership, it will have access to sensitive proprietary information, including the Jauhar Kindergarten student database and curriculum. The third partner agrees strictly not to disclose, use, or transfer such data to any third party, including its own tuition center chain, for any purpose other than the business of this LLP. For the non-competition, during the subsistence of the SYAUQI agreement and for a period of 2 years thereafter, the partners agree to not directly or indirectly engage in, manage, or operate any kindergarten business that competes directly with the LLP within a 10-kilometer radius of the Shah Alam and Seremban branches. Regarding the conflict of interest, the third partner declares its existing interest in Anak Kanda Cemerlang Sdn Bhd and agrees that any educational field, trips, or corporate sponsorship secured through its strategic networking must be prioritized the interest of this LLP over its own tuition centers. For the draft notes, this clause addresses the first partner concern regarding Alin who may take the student's database or curriculum for its own benefit. Thus, it legally requires Alin not to use the LLP data for her tuition centers and sets a clear non-compete rule to protect the kindergarten market.
Next, moving on to the assumption of liabilities and indemnity clause under this agreement. Firstly, it touches on the limitation of partners' liability. Under this clause, the partners to the LLP shall enjoy limited liability in accordance with the Limited Liability Partnership Act 2012 and shall not be personally liable for any debts, obligations, or liabilities of the LLP beyond their respective capital contributions, except where such liability arises as a result of fraud, willful misconduct, or negligence. Thus, each partners only liable to up to the extent of their capital contributions. Next, moving on to the liabilities of the LLP. Under this clause, any debts, obligations, or legal claims incurred by the LLP, including bank loans and credit facilities, shall be satisfied solely out of the assets of the LLP. The financial liabilities of the LLP shall not simply attach to the personal property of the partners by virtue of their being partners. Thus means that the assets of the partners themselves are protected and the debts can only be claimed through the assets of the LLP and not the other partners. Furthermore, this clause also touches on the liabilities in legal proceedings. In this agreement, any legal proceedings or action taken on the business of the LLP shall be brought against the LLP only, and no partner shall be referred to in any such proceedings except where either of the partners may have been guilty of some fraud, illegal act, or conduct which is outside the provisions of this agreement. Hence, this clause protects the legal obligation of the LLP partners and highlights that in case of any legal proceedings, only the LLP can be brought to court and not the individual partners. Next, moving on to the assumption of liabilities and indemnity in cases of pre-incorporation contract and liabilities. Any agreement, contract, or arrangement entered into by any partner prior to the incorporation of the LLP, including the transportation contract entered into between the first partner and safeguard bands, shall not be binding or render the LLP liable unless it specifies in writing that it agrees to assume such agreement, and where required by law, the agreement is duly novated in favor of the LLP. Thus, the contract between safeguard vans and the first partner regarding the transportation only binding on the first partner and not the LLP. Lastly, the assumption of liabilities and indemnity clause under this agreement touches on the indemnity for misconduct. In this clause, it is stated that where any loss, damage, or liability is suffered by the LLP as a result of a partner's fraud, willful misconduct, gross negligence, or unauthorized act, such partner shall fully indemnify the LLP and the other partners against all losses arising therefrom, which means that in case of any misconduct of the partners, the other partners and the LLP would not be liable. The drafting note behind this clause is that this clause enforces the statutory principle of limited liability by clearly separating the LLP's legal identity from the partners. As a result, the first partner, second partner, and the third partner are personally protected from the LLP debts, including bank loans. This clause protects the LLP by removing automatic liability for pre-incorporation contracts like the Safe Right Vans agreement with the first partner unless the contract is signed in writing. The indemnify provisions holds any parties who engages in misconduct personally responsible for any resulting losses instead of imposing liability on all the partners and also on the LLP itself.
For the employment continuity, following the registration and commencement of the LLP, all employees currently engaged in the business of Jaha Kindergarten at both the Shah Alam and Seremban branches will continue to be employed by the LLP without interruptions. The LLP would regard all current employees' earlier periods of employment as continuous service, and such employees will maintain all rights, seniority, benefits, and entitlement obtained prior to the creation of the LLP. All existing employee terms and conditions of employment, including pay, allowances, leave entitlements, and other contractual benefits, will also remain unaltered and will not be reduced as a result of the company transferred to the LLP. The LLP will assume and be responsible for all employment-related obligations and liabilities, including but not limited to salary payments, statutory contributions to the Employees Provident Fund, which is EPF, Social Security Organization, PERCESO, employment insurance, and any other statutory contractual obligations. Each of the employment contracts taken before by the first partner in his individual capacity for the purpose of operating the business would be deemed transferred and absorbed by the LLP upon its incorporation. Lastly, none of the employees will be regarded to have been dismissed or retrenched only because of the creation of the LLP or transfer of the business to LLP. For the drafting notes, this clause facilitates the transition of an existing employee from the sole proprietorship to the LLP without any interruption of an employment. It safeguards the interests of the first partner by retaining an experienced workforce and mitigating the risk of dismissal disputes. Furthermore, it safeguards the employee's right, benefits, and continuity of employment.